Well, much of the country is still reeling this morning after the Supreme Court essentially gutted affirmative action. Our 9 News legal analyst Whitney Traylor joins us now. Whitney, good morning.
Good morning. Good to see you.
By the way, the Supreme Court did just rule on the website designer here out of Colorado. We're going to get to that in just a moment. But first, we want to get back to affirmative action.
Yeah, what was your reaction to that decision? Was it surprising based off of what you had been hearing and following?
I think it was surprised and I wasn't surprised. So yes, I was a little bit surprised because there was so much precedent. And this started back in 1978 with the Bakke case, in which the court said quotas were unlawful, but that you could use race as a factor. And so John Roberts, this court likes to rely on precedent. So, and that was affirmed in 2003 in the Grutter case. And so we have a lot of precedent to establish this, and there's a lot of statistics showing that this has been a good thing to include race as one admission factor for qualified students. On the other hand, I'm not surprised because this court has been very conservative and they've made a lot of rulings. They went against precedent just recently, obviously, with the Dobbs decision as well.
Whitney, what's next from here? Where do we go and what should we expect to see?
Well, you heard, I heard in the lead-in some of the folks saying that they're expecting a drop. We saw that in the states that have eliminated this as a factor, that it has dropped the attendance of minority students. But the reality is, there's so many considerations in the admissions process. So you have to start with the notion that the students are all qualified, first of all. But the question is what factors are considered. So a lot of people are criticizing the decision because they say, well, legacy, if you're a son or daughter of somebody who went to the school, if you're a first-time student, your geography, if you were raised on a farm, all of these things are added into the mix, and courts and admissions folks can consider it. So when they say, well, you're just focusing on the race piece, they're saying that, look, that is not fair. That's the criticism.
Pretty much right away, the president put out guidelines to try to boost diversity and said that he was against this ruling. What kind of power does he have over admissions versus will we now see universities and colleges kind of coming up with their own plans and individualized plans?
Well, I think you're going to see both. You're going to see colleges and universities trying to comply with the law while also maintaining a diverse student body. But the White House gave this instruction. The instruction is not law in and of itself, but it can be something that the courts or that the schools can look to when they're defending their policy, saying, look, we're also compliant with the White House. So we're going to see a lot of litigation because even in John Roberts' majority, in his opinion, he wrote that race can still be mentioned in your essays and can be sort of factored in other ways if you had to overcome certain barriers or if it's a point of pride or something like that. So he didn't necessarily, completely eliminate that. So, but now as you have colleges trying to adopt and adjust to this new ruling, you're going to have lots of litigation going forward.
All right, we want to get back to that ruling that just came down from the Supreme Court, one we've been expecting to see any minute now. We just learned the Supreme Court ruled in favor of a website designer here in Colorado. Yes. The argument there was that she didn't want to make wedding websites for same-sex couples. The Supreme Court, again, ruling in her favor 6-3 there. Where do we go with this one now?
Well, this is going to lead to significant litigation because here's why. So now, and I didn't read the opinion, I think it just came out.
Yeah.
So the issue here is she's saying you're compelling me to give speech. My website designs are my artistic expression. This is who I am. And so government, you can't compel me to say something that goes against my religion and goes against my fundamental beliefs. Now that's going to open the door, though, for interracial couples, for Jewish couples, for black couples, somebody saying, hey, this goes against my religion. I'm not going to be forced to give this message. And then the question is going to be, well, when are you performing your job or versus when it's an artistic creation? So, for example, at a wedding, if the caterer says, I disagree with interracial marriages, I'm not going to provide these catering services, right? So is that their artistic expression or is this them denying a service? So I think what you're going to see across the country is people being denied service on these very specific characteristics and having litigation.
I know that these decisions have just come down, but it seems like it's going to be lending to that litigation and debate and people fighting back on both sides.
That's exactly right, because the law was pretty clear that you can't deny people service based on these certain characteristics. And in Colorado, we have a state law that's it's in our statute. And so now this is, I think this, I haven't read the opinion, so maybe it's very specific.
Right.
There may be unique nuances to it, but just its ruling in and of itself, this is going to give service providers, business owners the right to say, I disagree with this, same-sex marriages, interracial, this religion, whatever, and we're going to deny service.
All right, well, as you can imagine, this is only the tip of the coverage that we're going to have for the rest of the day. You can follow along here on the networks of 9 News as well as on 9news.com for that, Whitney. Thank you for being with us.
Sure, good to be here.